Hear me?
Yes, my lord.
No. Okay, good morning. I'm so sorry for coming in a bit late. I'm having kata. Yes, Miss. This case of is it Jeto Daniel Sunday, Mr. Kasali Wahid, you are in the matter, ba? You are muted, Mr. Wahid. Unmute yourself.
My lord, my name is Kayode Omoshen. I'm also in the Sunday and Bua.
Okay, it's okay. The Jeto Sunday Bua. Jeto.
Yes, my lord.
You are Kayode
Omoshen for the claimant. Omoshen. Omosehen.
Yes, for the claimant.
Yes, my lord. I don't know if the matter. I don't know if my lord is ready to go on because I have some other colleagues that I'm appearing with.
Yes, you can appear with them with.
Okay, I have Damilola Alabi. Alabi.
Yes.
That's the only counsel who has put on his camera. I don't know if others are there, so I don't want to announce. Damilola Alabi appears with me for the claimant.
Okay, for the claimant.
Yes.
Mr. Wahid. Mr. Wahid, you are muted.
Mr. Kasali, please unmute yourself. Mr. Kasali, we have been hearing your voice since the beginning of this session. What happened now?
Maybe he's trying to get his secretary to Mr. Wahid.
I'm not even sure he can hear us. Mr. Wahid.
Mr. Wahid, these things are user friendly. Mr. Wahid, you don't need to call your secretary. You don't need to call your secretary to unmute you. Mr. Wahid, hey, the secretary, he's muted.
My lord, I'm very sorry about your lordship's health. This condition is
it's okay.
This condition seems to be pervading the country now.
We thank Almighty God for everything.
I wish your lordship's
Mr. White, are you now? Oh.
It's still muted.
It's like Mr. White is still.
And the device has been working perfectly.
Madam Secretary, it's just to unmute him. Don't go and touch any other thing, just to unmute him. Just go to touch that mute. Can you see mute? Yes, you have mute, you have stop video, you have share content, you have participants. So go to mute. Click on the mute.
My lord, if your lordship so permits, I would suggest that Mr. Kasali to write his name into the box. Your lordship can see his face.
Okay.
So that we can make progress.
Or maybe you can go to more. Then under more, there are some items: chat, AI companion, record, apps, captions. So maybe you can write, you can. Mr. Wahid. Mr. Wahid. Okay, Mr. Kayode, you know what you do?
Yes, my lord.
Do you have Mr. Wahid's number?
I suppose I do.
You can call him, then put it on speakerphone, so that we'll take his appearance. Then I'll proceed with this. Since he can be able to hear me, it's only him that we can't hear. So
yes,
once his appearance is taken.
Yes, my lord.
Yes,
That's
yeah,
but
what is the challenge?
the challenge
Yes.
I have is that the phone that I'm using for this proceeding is also what I would likely use to call.
Yes. What? Okay, but what you just do is just to.
Okay, maybe I can call him on WhatsApp if it's there on WhatsApp.
Okay, maybe. Okay, we've even lost Timber.
Okay, maybe he wants to reconnect.
Okay, no, let me see. He's still there. Oh, no, he's not. Okay, yes, maybe he'll want to reconnect.
Alternatively, my lord,
Yes.
your lordship can deem his appearance announced, given the fact that he has signed into this uh, proceeding,
Okay.
and the business of the day is for the delivery of
Let me,
judgment, which which requires the minimal participation of counsel.
okay. Okay. Let me just proceed.
As a complicit.
And he can even
That's correct. You
rejoin
can announce, yes, and announce an appearance later.
in the course of the proceedings.
As a complicit.
So the claimant commenced this suit by a complaint and other accompanying processes filed on the 14th of February 2020 and asked for the following reliefs as contained in the statement of facts against the defendant. Number one, a declaration that the defendant refusal to recall the claimant back to work on 27th March 2014 and or pay the monthly salaries of the claimant after serving 3 months suspension. It's an unlawful and unfair labor practice and inconsistent with international best practices. Number two, a declaration that the claimant's employment with the defendant subsists and that the defendant's internal memo for the claimant suspension dated 27th December 2013 cannot amount to termination. Or, in the alternative, a declaration that the defendant refusal to recall the claimant back to work on 27th March 2014 after serving the 3 months suspension without pay amounts to constructive and unfair dismissal of the claimant and unfair labor practice. Number five, an order directing the defendant to pay the claimant within 7 days all his monthly salaries and allowances and employer/defendant's contributory pensions at 10% of the claimant's monthly salaries from April 2014 to the date of judgment, or an award of cost of this suit in the sum of 1 million naira against the defendant for his willful refusal to settle this matter amicably and forcing the claimant to proceed to litigation. As usual, the defendant, in reaction to the suit, filed a statement of defense on 30th of June 2021 via leave of court granted on 7th of July 2021. Meanwhile, a reply to the statement of defense was also filed by the claimant on the 30th of June 2021. The crux of the claimant's case is that he was employed by the defendant as office assistant on 27th October 1998 and confirmed in January and November 2021 after about 13 years, which according to the claimant amounts to unfair labor practice. That he was attached to the office of the chairman of the defendant company and was responsible for serving food, tea, and drinks to the chairman of the defendant to ensure the comfort of the chairman. It was advised by the claimant that the defendant issued him a 3-month suspension without pay for alleged dereliction of duty and a warning to sit up in his job. That after serving the 3-month suspension, he resumed work at the defendant's office, but he was informed by the Human Resources Department and the secretary to the chairman that the chairman had directed that the claimant should wait for further instructions and not resume work. That he continued to go to the defendant's office to ask if his resumption was approved, but he was prevented from resuming work. That his salaries and pension contributions were stopped in December 2013. Claimant contended that the defendant refused to allow him to resume work and failed to recall him to work after 3 months suspension. That the claimant reported the issue to the Public Complaint Commission, but the defendant did not honor the commission's invitation. Claimant in his reply to the statement of defense stated that his employment was neither determined by the defendant nor abandoned by him. He also contended that he was never given the defendant's handbook throughout the period of his employment with the defendant. The case of the defendant is, however, that the claimant was issued a suspension as punishment for the dereliction of duty and to also serve as a warning to him to take his duties seriously, that it was a suspension that precipitated and culminated in the termination of the claimant's employment with the defendant. The defendant also averred that after the claimant's 3-month suspension had elapsed, the claimant failed to resume at the defendant's office, thereby abandoning his employment with the defendant. That his failure to resume work put an end to his status as an employee of the defendant in accordance with the defendant's staff handbook. It was further stated that it was the claimant's abandonment of his employment that put an end to his employment with the defendant, by reason of which the claimant ceased to be entitled to salaries and mandatory pension contributions. The defendant contended that this suit is statute barred, as the claimant was precluded by law from filing same at the time limited by the relevant statutory provisions for filing same had elapsed before it was filed. Trial. When the matter was adjourned to the 7th of July 2021 for hearing, claimant testified as CW1 and adopted his 2 statements on oath dated 14th of February 2022 and 30th of June 2021, and tendered exhibits J2 1 and J2 to J2 6. CW1 was then cross-examined, re-examined, and later discharged. On the 26th of October 2022, Mary Grade Elora testified as CDW1. She adopted her statement on oath dated 28 May 2022 and was cross-examined and discharged as there was no re-examination. The matter was then adjourned for adoption of final written addresses. Defendant's final written addresses. The defendant's final written addresses. The defendant filed his final written address on 23rd of January 2023, wherein a sole issue for termination was raised to it. And I quote, whether the claimant has proved his case to make him entitled to all his reliefs, unquote. Learned counsel for the defendant submitted that it is the duty of the claimant to prove his case against the defendant. Counsel cited the Supreme Court case of Okoye and Nwanko, that the burden of proof in civil cases has 2 distinct meanings. These, the first being the legal burden or the burden of establishing a case, and the second is the burden of proof, usually described as the evidential burden. Section 133 of the Evidence Act was also cited that in civil cases, the burden of first proving the existence or non-existence of a fact lies on the party against whom the judgment of the court will be given if no evidence were produced on either side, regard being heard to any presumption that may arise on the pleadings. Submitting for that, counsel stated that the claimant's claim in his pleadings, among other reliefs, the defendant's refusal to recall him to work and to pay his monthly salaries after serving the 3-month suspension. However, according to the defendant, the claimant never resumed work after the 3-month suspension, and therefore determined his employment with the defendant in line with the contract of employment between the parties. Now, the document which regulates the relationship between an employer and employee is the contract of employment between the parties. Counsel referred to Exhibit J21, which is the letter of employment dated on the 7th of October 1998. Counsel also referred to the case of Al-Hassan and Abu Zaria. And counsel argued that even though the claimant denies being given the defendant's staff handbook throughout the period of his employment with the defendant, but the claimant having been employed by the defendant for 16 years, said under cross-examination that he was aware that there was a handbook. The DW1 also maintained during cross-examination that both the claimant's letter of employment and the staff handbook were given to him as it is the usual practice of the company. Counsel further argued that the claimant has been inconsistent in his evidence, hence not a witness of truth. That it is strict law that when there is a contradiction in the pleadings and evidence adduced by a party, the court will discountenance such evidence. Citing the case of Oguntayo and Adebutu. Ghana Council contended that the claimant never resumed his suspension that is expressly stated in the handbook that where an employee is absent from work for 3 consecutive days or more without permission, it means his duty is deemed abandoned. Pursuant to clause 15A of the Boer Group Staff Handbook, that the claimant cannot therefore claim for any entitlement as per all his reliefs. Claimants alleged unfair labor practice. It was contended that nothing is pleaded or proved by the claimant that can be construed to constitute unfair labor practice on the part of the defendant. That mere invoking the phrase unfair labor practice without more is not enough to sway the court from applying the rules of evidence. Citing sections 131 and 133 of the Evidence Act. Counsel further contended that the claimant was well remunerated while working with the defendant and never showed any evidence or complaint of unfair labor practice by the defendant before this honorable court. Defendant's counsel also argued that claimant's claim for overtime is unsubstantiated and shall be discountenanced by the court. Counsel further submitted that the claimant tendered exhibit J205, which is the statement of account in support of relief 4 of his claim. However, the claimant failed to explain to the court various interests showing payment or deductions of money in his salaries in the statement of account, but just dumped the statement of account on the court without offering any explanation as alleged in the pleadings. Set in the case of Ejiogu and NDIC, that exhibit J205 has no evidential value on the ground that it was merely dumped on the court. Now, the law is certain that a document tendered in the course of proceeding does not relieve the party of the legal duty to link the document with his case, i.e., the allegation that the defendant has been remitting an amount less than 10% of his monthly salaries as his contributory pension was not linked with the case of the claimant. Claimant's final written address. Claimant's final written address is dated and filed on 15 February 2023. Wherein 2 issues for determination were raised to it, and I quote. Number 1, whether in view of the fact evidence of the parties and the state of the law, the claimant's employment with the defendant subsists as a result of indefinite suspension or has been lawfully terminated as a result of abandonment of duty. Number 2, if the answer to issue 1 is resolved in favor of the claimant, whether the claimant is entitled to reliefs 1, 2, 4, 5, and 5 in this case. Land Counsel for the claimant submitted on issue 1 that the claimant was suspended for 3 months without pay and that the claimant's employment has not been terminated by the defendant. And the claimant remains on indefinite suspension as the defendant denied the claimant to resume work. That's in the case of Abaya, Ayabam, and Benue State government. Counsel also refer the court to paragraphs 17 and 22 of the claimant's witness statement on oath. That CW1 made a further statement in paragraph 4 of his further witness statement on oath to correct his earlier statement in paragraphs 21 and 23 of his written deposition. That this statement was reinforced under cross-examination. Citing also the case of Adeosun and Governor of Ekiti State. It's also a submission of counsel that the defendant's argument that the claimant abandoned his duty is a desperate attempt to cover up their lapses regarding the suspended staff and an afterthought, they have no evidence of the claimant's abandoning his employment. It was argued that the testimony of the defendant that the claimant did not resume work after suspension is speculative. Claimant's counsel also argued that the claimant complied with the advice of the head of human resources of the defendant, and later reported the defendant to the Public Complaint Commission, but all to no avail. It is a contention of counsel that, contrary to submission of the defendant's counsel, there is no material contradiction in the claimant's testimony. That the claimant corrected the dates which he did not meet the chairman of the defendant in his further witness statement on oath, which is consistent with his evidence under cross-examination. That the defendant witness admitted under cross-examination that the claimant had never abandoned his work. Counsel submitted that the claimant's employment was not terminated after the end of his suspension, and no disciplinary proceeding was held to inquire why he was absent from work. Counsel also contended that the defendant acted unlawfully by suspending the claimant without pay as against Exhibit Bua 1C, which does not confer the defendant with such power, relying on the case of Ibirokba and Counsel Federal Polytechnic Yaba. To the full contention of counsel that the defendant is duty-bound to either recall or disengage the claimant, but the defendant never did either, relying also on Globe Motors Holding Nigeria Limited and Oye Ole. Counsel submitted that Clause 15A of Exhibit Bua 1 does not apply to the claimant as he did not abandon his duty without justification. That any employer who accuses an employee of abandonment of duty ought to afford the employee fair hearing before deeming his employment abandoned. On issue 2, counsel applied to withdraw claimant's relief 3 and urged the court to strike out same. Counsel then submitted that the claimant has satisfied the requirement of the law, reliefs 1 and 2, by showing that the defendant suspended him unlawfully without pay and prevented him from resuming by never calling him back despite his effort to resume. That he was asked to go home by the head of the defendant's human resources until further notice. It was also submitted that a suspended employee remains an employee until his employment is terminated. Citing the case of Lounge and FBN, that the defendant's procedure for termination of an employee, as provided in Clause 8, page 15 of Exhibit Bua 1C, was not complied with by the defendant. Counsel further submitted that Exhibit J205, which is not a computer-generated evidence, was tendered following the defendant's refusal to produce the claimant's pay slips, despite the notice to produce in paragraph 17 of the Statement of Fact. Counsel relied on Section 12 of the National Industrial Code Act to submit that J205 is not only relevant, but also admissible, being an original document with First Bank's blue ink stamp on it. The other counsels maintain that, which is for the course of this series, not an alternative to 4, but to relief 5. Counsel therefore urged the court to read the word "o" after relief 5 conjunctively and as "and" in the interest of justice. That Exhibit J206 was written to the defendant to resolve the matter, but the defendant ignored to respond to the letter. Therefore, the claimant is entitled to the cost of this action in addition to his salary arrears. In conclusion, counsel urged the court to grant all his reliefs. Defendant's reply to the claimant's final written address. The defendant filed his reply on points of law on 16th of March 2023 and submitted that the defendant has no obligation in the contract of employment to recall the claimant who refused to come to work for 3 consecutive days, as it is tried that parties are bound by their agreement. Counsel also submitted that the claimant received his salary and other emolument when he was in the employment of the defendant, and it's not true that the claimant was suspended without being given a fair hearing or query. Rather, the abandonment of the claimant's employment put an end to his employment of the defendant. That in so doing, the claimant ceased to be entitled to salaries and pension contributions. That all through the pleadings, the claimant did not challenge the query given to him, but he admitted the contents of the query, which is in line with his contract of employment. Counsel further submitted that the defendant is not under any duty to take further steps by investigating the whereabouts of the claimant who deliberately abandoned his work after serving his suspension or attend a meeting with public complaint or reply any letter whatsoever with regards to the claimant who left the service of the defendant for almost 6 years. It's a submission of counsel that the claimant who gave evidence that he resumed work and met with the chairman, secretary, and human resource and head of human resources department ought to subpoena those staff to come to court and give evidence, but rather failed to do so. That in view of the fact that the claimant has failed to prove his case by issuing a subpoena on the alleged staff of the defendant he claimed he saw on the 7th of March 2020, it is contended that the burden of proof to prove his case rests on the claimant who alleged such a fact and not the other way round. So this is my opinion. After thoroughly reviewing the parties' pleadings and the evidence adduced, as well as the submissions and issues presented, I have decided to focus on the single issue raised by the defendant. This issue encompasses all the key points and will effectively address the two issues raised by the claimant. The issue is thus, and I quote, well, the claimant has proved his case to make him entitled to all his reliefs. Unquote. Let me quickly observe that the defendant in paragraph 18 of its statement of defense has alluded to the fact that it shall contain at the trial at any stage of the proceeding that the claimant's suit is statute barred. Meanwhile, on 30th June 2021, the defendant filed a notice of perennial objection, contending that the claimant's suit is cut off by limitation law of Lagos State. Let me further observe that the defendant did not move his notice of perennial objection, nor incorporate same in his final written address. Essentially, the attention of the court was not drawn to the said notice of objection. It is the law that it's the duty of an applicant to take steps to initiate the hearing of his motion, and when that's not done, then such applicant would be said to have abandoned his motion. In the instance case, the defendant having failed to move his notice of objection, dated and filed on the 30th June 2021, is deemed to have abandoned same and is accordingly struck out. See the case of Obiozo and Namua. For what it is settled law that a case or action is said to be statute barred when or if it is commenced or initiated after statutory timeline within which it can be brought had expired or lapsed, while statute has prescribed and limited the period of time within which an action or case may be filed by a person in a court of law. Any action filed outside or after the time prescribed and had ended, such a case or action will be in contravention of the provision of the statute and is consequently be barred by the statute. See the case of INEC and Obadibo, local government. That according to section 8(1)(a) of the limitation law of Lagos State, actions founded on simple contract shall not be brought after the expiration of 6 years from the date the cause of action accrued. However, it becomes imperative to note that the time begins to run for the purpose of the limitation law from the date the cause of action accrues. And in determining whether an action is statute barred, claimants' complaint and statement of facts are the determinant factors to ascertain the date the cause of action accrued and the date the action was commenced. It's clear from the complaint and statement of fact of the claimant that the cause of action accrued at the end of the 3-month suspension of the claimant. The claimant's suspension, which is the basis of the claim, occurred on 27th of December 2013, and the action was filed on February 14, 2020, which is within the 6-year time frame as provided by section 8(1) of the limitation law of Lagos State. It follows, therefore, that the contention of the defendant that this matter is statute barred is untenable and is hereby discountenanced. Consequently, notice of perennial objection on that basis is overruled and is hereby dismissed. Turning to the meat of the case, the grievance of the claimant is that he was suspended by the defendant for 3 months, and when he attempted to resume work after the suspension, the defendant refused to allow him to resume work and failed to recall him to work. However, the defendant on his part contended that the claimant never resumed work after the 3-month suspension, and that amounts to abandonment of duty. It was also contended by the defendant that there is no evidence to show that the claimant resumed work. Neither is there any evidence that the defendant prevented him from resuming work. Generally, the law is that an employer has inherent powers to discipline its employee according to contract of employment, while the conduct of the employee constitutes a misconduct or infraction. See the case of Arinze and First Bank of Nigeria Limited. In the same vein, an employer has the right to suspend any of his or its staff if there exists reasonable ground to do so. In Udema and Nigerian Coal Corporation, the Court of Appeal has held that the right to suspend an employee is available to an employer in order to effect proper investigation of allegations or during the process of a disciplinary action. See the case of Beforfe and Unijust Consultancy Limited. The right to suspend an employee when necessary, either as a punishment, as in the instant case, or to enable the investigation of an infraction, is an integral part of the employer's right to discipline a staff. But other than as aforesaid, in the regulation of an employment relationship, the power to suspend an employee is not an implied term in an ordinary contract between an employer and an employee. The Labor Act did not make a provision regarding suspension a mandatory requirement. See the case of Launch and FBN, City Central Group of Companies, and AZ. In suspending an employee for the purpose of investigation or disciplinary action, the employer must comply with any existing regulation governing procedure. But such power can only be the creation of either a statute governing the body or of an express term in the contract itself. Therefore, where a contract of employment is not one with statutory flavor, for suspension to be validly made, it must be so provided in the employment contract or in the handbook regulating the terms of the employment. See the case of Globe Motors Holding Nigeria Limited and Oyewole, Elizabeth and Ondo JSC. It is instructive to point out that suspension is not a termination of the employment contract, nor a dismissal of the employee. And the implication is that the employee is still in continuous employment of the employer until it's recalled or formally terminated or dismissed. Pending his recall or dismissal, a suspended employee is entitled to his wages or salary during the period of suspension, unless the terms of the contract of employment or the letter of suspension itself is specific that suspended employer will not be paid salaries during the period of suspension. See the case of NJC and Danjidda. The defendant contended that the claimant never resumed work after his 3-month suspension and that the claimant abandoned his duty, relying on clause 15A of the defendant's staff handbook, Exhibit 1, on job abandonment, which states thus, and I quote, any employee who absents himself/herself from duty for 3 consecutive days or more without any permission will be deemed to have abandoned his or her job and voluntarily withdrawn from the service of the company, unquote. It was stated by DW1 under cross-examination that Exhibit BUA 1A and B contains the claimant's two addresses and phone numbers. The defendant did not invite the claimant when he did not resume because the defendant handbook says that an employment is determined when an employee is absent for 3 consecutive days. DW1 also stated that the best practice approach to a long-serving employee with no prior record of abandonment when he's absent for days is to refer to the handbook. It was also the testimony of DW1 under cross-examination that the claimant reported the defendant to the Public Complaint Commission, but the defendant did not honor same. CW1, on the other hand, said under cross-examination that after his suspension, he resumed work on 27/3/2014, but the head of Human Resources Department said that he should go and they will get back to him. But since that time, he never heard from them. It was the contention of the defendant that he did not need to invite the claimant when he did not resume work because its handbook says when an employee is absent for 3 consecutive days, his employment is deemed determined. I observed from the questions put to the defendant witness under cross-examination that the claimant was on leave when he was suspended, and he was invited by the Human Resources Department to go and receive his suspension letter. I also observed that the claimant had served the defendant for about 15 years. It is surprising that the defendant would invite the claimant to go and receive his suspension letter when he was on leave. But the defendant could not look for the claimant and ask about his whereabouts when he was just absent for 3 consecutive days. To me, the proper thing to do by the defendant was to look for the claimant and find out the reason for his absence before he deemed his employment determined. After all, the claimant averted at paragraphs 17 and 19 of his deposition, statement of facts, that upon the expiration of his suspension period, he dressed up and resumed at the defendant's office. But the chairman, secretary, and the head of Human Resources Department informed him that he should hold on until he heard from the chairman. Even though clause 15A of the defendant's handbook says that an employee who absent himself from duty for 3 consecutive days without permission would be deemed to have abandoned his duty and withdrawn from the service of the company. But I have the view that this will only happen when inquiries and investigations are made and it's actually found out that the employee absented from duty without any doubt. Regardless of clause 15A of Exhibit BUA 1, the claimant should still be given fair hearing on the alleged misconduct abandonment of duty. My view is that clause 15A of BUA Exhibit BUA 1C cannot override the general principles of fair hearing. Clause 15A is just a presumption that is rebuttable. That was the more reason why the defendant should have made inquiries and investigation about the claimant's absence from duty. I think the question whether the claimant resumed work or not does not even arise. What is important is whether the defendant had taken steps to investigate the whereabouts of the claimant with a view to giving him fair hearing. I do not therefore agree with the defendant that the best approach to a long-serving employee with no prior record of abandonment was to apply clause 15A of the handbook when he's just absent for 3 days. It's unreasonable for the defendant to refuse to take any action by investigating the whereabouts of the defendant, of the claimant, before he deemed his employment abandoned. The action of the defendant of not investigating the whereabouts of the claimant undermines not only the principle of fair hearing, but the long-standing employment relationship that had been in existence between the claimant and the defendant. I agree with the claimant's submission that clause 15A of Exhibit BUA 1 consider an unfair term, which is unreasonable. It will sound very uncommon that the claimant who had worked with the defendant for 15 years would just determine his employment by abandoning his duty. I think it will have cost the defendant nothing to look for the claimant through his addresses and phone numbers, which are available on Exhibit BOA 1, A and C, to know his reasons for the alleged abandonment of duty. Arising from the above, therefore, I do not believe that the claimant abandoned his duty after his 3-month suspension. I found that the claimant attempted to resume at his workplace, but was asked to hold on until he heard from the chairman of the defendant. To me, the claimant has been able to prove his case against the defendant. I hereby declared an order as follows. Number 1, a declaration that the defendant refusal to recall the claimant to work and or pay the monthly salaries of the claimant after serving 3-month suspension is wrongful and an unfair labor practice. Number 2, a declaration that the defendant's internal memo dated on 7 December 2030 suspending the claimant does not amount to termination. Number 3, okay, claimant's relief 3 having been withdrawn after parties have joined issues is hereby dismissed. After all, it is an alternative relief. Cost of 200,000 naira is awarded in, an order directing the defendant to pay the claimant all his monthly salaries from April 2014 to 14th February 2022, when the claimant instituted this action, and the employment is not one protected by statute. Claimant relief 3 having been withdrawn after parties have joined issues is hereby dismissed. After all, it is an alternative relief. Cost of 200,000 naira is awarded in favor of the claimant against the defendant. That is my judgment.
My Lord, we are very, very grateful for the industry that your Lordship has shown. And this is despite your Lordship's health, which I was surprised that your Lordship would go through the all of the judgments. I was hoping that your Lordship would just go straight to the decision of the court to avoid further stress on your Lordship's health. My Lord, we are very much grateful for your Lordship's industry, and we pray that the Lord will grant your Lordship good health and fast recovery. My Lord, please, we don't know what else to say, but to thank your Lordship again. Thank you, my Lord.
Thank you, Mr. Harry. Mr. Kasali.
My Lord, we are very grateful for a well-considered judgment.
Thank you, Mr. Wahid. Thank you, Mr. Wahid. Thank you. Thank you. Yes, Mr. Wahid, I can hear you.
Thank you. My Lord?
Yes, Mr. Wahid, I can hear you.
Yes, I didn't get your Lordship clearly as regards starting from April, so. I didn't get that area, sir.
Yes, the payment will start from, it's suspended him for 3 months.
Yes, my Lord.
I think sometimes in December 2013, and he was to resume work in March, isn't it?
Yes, my Lord.
So the payment will start from that April 2014 to the date of institution of the action.
Okay, from April 14 to the date of institution of the action.
Yes.
Okay.
Yes.
The date of institution as a copplaces.
Yes, we will send the copies of the judgment to you.
My Lord.
Yes. The online and the soft and the hard copies.
I'm very
send it.
grateful, my Lord.
Yes, you get it from the registrar Hajia.
Right.
In Lagos office. In Lagos office.
Yes. And if you even want the in online CTC, you can also apply it, via our portal.
Okay, sir.
Yes.
My Lord, I wanted to confirm, sir.
Yes.
If we want to apply for confirmation letter and record of proceeding, as well as certified copies of the court process file, should we
Yes.
be directing our application to Lagos office or to your Lordship's court in Uyo?
Yes, to me.
As a
But
copy.
the confirmation letter to me, but what do you call it? The record proceeding to Lagos office.
Certified copy. Okay.
Yes, Lagos office.
Okay.
Yes.
As a copy.
Thank you.
We are very grateful, sir.
Okay, thank you, Mr. Kayode. Mr. Kasali,
As a copy.
thank you so
Yes,
much.
thank you.
Thank you. I wish you well.
Thank you, my
Thank
Lord.
you, my Lord. Thank you.
Thank you. Have a nice day.
You too, my Lord. My Lord, sorry, my Lord, not to interject in the next proceeding, but
Yes.
and I'm not a doctor, but I
Yes.
have also been in this condition that my Lord appears to be today, sometimes
Yes.
last week, and it
Okay.
wasn't just only me, my colleagues as well, including the gentleman that appeared with me today. So
Okay.
maybe my Lord should take it easy by simply just refer to the decision of court without going through the hall as
Okay.
your lordship did,
Okay.
in our own judgments, so that your
Okay.
lordship can rest and attend to medical advice.
Thank you, Mr. Kayode. Thank you so much.
As a court, please.
Thank you for the concern. Thank you.
As a court, please.
Hello, Mr. Benjamin, and the hello.
Hello, sir. Well, yes, sir.
Yes, Mr. Benjamin, Mr. Yeah, welcome back.
Yeah. Thank you, my lord.
Thank you.
Yes.
So Mr. Benjamin Tomoloju.
Yes, my lord. Tomoloju is spelled Tomoloju. My appearance is for the claimant. And the claimant is also present, my lord.
Okay. Benjamin Tomoloju. Yes, for the claimant.
Yes, my lord.
Okay, claimant present.
Yes, my lord. The claimant is present.
Yes, Miss.
May it please your lordship, O Onosoya. My appearance is for the defendant, sir. Lord, the defendant's representative is also online, sir. Miss Elizabeth Ebon.
Okay. Okay, so the defendant is represented by
Elizabeth Ebon. She's online, sir.
Okay. As what? Mr. She's what?
The legal officer, sir.
Okay, legal officer.
Legal officer, sir.
Okay, I see. So this is my judgment. The claimant commenced this suit by a complaint and accompanying processes dated and filed on the 12th of April 2019 and asked for the following reliefs as contained in statement of facts against the defendant. Number one, a declaration that the claimant is entitled to a right to fair hearing as provided for under Section 30 of the National Constitution as amended. Number two, a declaration that the claimant was not availed with any opportunity to defend herself of the allegation of crime level against her, and thereby deprived her of her right to fair hearing as enshrined in the Constitution of the Federal Republic of Nigeria, thereby amounting to a wrongful dismissal. Number three, a declaration that the dismissal of the claimant by issuing her a dismissal letter on the grounds of an alleged criminal gross misconduct of theft without first granting her fair hearing or availing her an opportunity to defend herself, either before an administrative panel or a formal criminal charge before a competent court of law, or full trial running to a conclusive end, and the court finding her guilty or not is unlawful, illegal, void, of no effect whatsoever. A declaration that the criminal charge brought against the claimant before the Iboshari Magistrate Court, Lagos State, on grounds of complaint from the defendant to the police, and the application to withdraw statement, and indeed the withdrawal of the charge at the instance of the defendant, after the claimant has been arraigned remanded in prison custody, granted bail, and trial already commenced with prosecution witnesses already testifying, was only a ploy to provide a cover to lawfully dismiss the claimant as against the laid down procedure and process for dismissing an employee with respect to a case of alleged criminal misconduct. A declaration that the criminal charge brought against the claimant before an abortion magistrate court Lagos State on grounds of a complaint from the defendant to the police and the application to withdraw same, and indeed the withdrawal of the charge at the instance of the defendant after the claimant had been arrested, arraigned, remanded in prison custody, granted bail, and trial already commenced with prosecution witnesses already testifying, amounts to malicious prosecution. Number 6, an order of this honorable court directing the defendant to pay to the claimant the sum of 990,000 naira, being accumulative of 33 months' salary arrears of the claimant at 30,000 naira per month from July 2016 to March 2019, and 30,000 naira monthly, being a monthly salary from the month of April 2019 until the month the matter is finally dispensed with and judgment entered in favor of the claimant. And 10% interest on the total judgment date sum from the date judgment is given to the date judgment is the date is finally liquidated. An order of this honorable court directing the defendant to pay to the claimant the sum of 5 million naira as general damages for inconveniences, pain, and trauma caused the claimant during the period of dismissal. An order of this honorable court directing the defendant to pay to the claimant the sum of 5 million naira only as exemplary damages for malicious prosecution. And for such further orders or orders as this honorable court may deem fit to make in the circumstance. The defendant, in action to the claimant, should enter the appearance and file a statement of defense on 17th of May 2019 by leave of court granted on the 18th of March 2020. Meanwhile, the claimant on 24th May 2019 filed a reply to the statement of defense, but without the further deposition on oath. Case of the claimant. From the pleadings filed by the claimant and her testimony, she was employed by the defendant as pharmacy technician via an offer an offer letter dated 6th May 2014 and confirmed on 13th March 2015. Claimant avowed that she has worked with the defendant as pharmacy technician for 25 months and 6 days before the incident that led to a wrongful dismissal. Claimant said that she was known for honesty, diligence, and good character prior to the false allegation leveled against her by the defendant. Claimant also avowed that on the 15th of June 2016, after a close of work around 3 p.m., some staff of the defendant confronted her with questions as to a missing money to the tune of 14,000 naira. But the claimant was full of shock and surprise and vehemently denied any knowledge of the missing money. That toward the closing hour, the staff of the defendant invited the claimant and one other staff for a search, which the claimant complied with, but no missing money or any other thing was found on her. Claimant stated that when she resumed work the following day, the managing director of the defendant ordered for her arrest, and she was then arrested by the police and taken to Bar Beach police station. That she was detained by the police and denied bail on the instruction of the defendant. Claimant also stated that she was taken to magistrate court and remanded to prison, where she stayed for about 41 days in prison. That while she was in prison, the defendant on the 22nd of July 2016 issued a letter of dismissal to the claimant. Claimant further stated that she was never invited to any panel to be heard or given opportunity to provide explanation or defend herself about the allegations leveled against her. It was also stated that during her stay in Kirikiri prison, she fell ill due to various infections and ailments, where she spent so much money on medical treatment. That the case at the magistrate court lingered till February 2019, when it was struck out upon an oral application made by the prosecution. It is the contention of the claimant that she has suffered incessant hardship as a result of the wrongful dismissal and discharge level against her by the defendant, that she has not been able to get another job as a result of the level of damage the allegation of theft the defendant has done to a person, that she has suffered emotional pain and physical torture, loss of reputation and dignity. The defendant's case is, however, that prior to the claimant dismissal from the employment of the defendant, she was assigned to one of the defendant branches. And during her stay at the said branch, there was a shortage of money made from the day's sales. And the audit department had been on the lookout to apprehend the culprits. It was discovered that on 15 June 2016, the sum of 14,000 naira was missing from the day's sales. And the audit department began immediate investigation by questioning all the staff on duty. The defendant stated that it was discovered that the cumulative amount missing over a period of time amounted to 2,200,000 naira. That in the course of the questioning of the staff on duty, one Annabelle Onwudi, who was a core staff of the claimant, started behaving in a suspicious manner. I requested to go into changing room before she could be searched. That upon her exiting the changing room and upon further search, the missing money was found hidden in the said room. It was also stated by the defendant that the police was invited to investigate the incident, and upon investigation, the core staff informed the police that the claimant was involved in the theft. The claimant was invited to the police station without notifying the defendant. The defendant denies the claimant's allegation that she was not given the opportunity to defend herself before she was charged to court. According to the defendant, she withdrew the discharge and decided to settle the matter out of court. The defendant further stated that the claimant was questioned by the audit department, who gave the claimant an opportunity to defend herself. The defendant dismissed the claimant 1 month after the theft incident. At the close of pleadings, trial commenced on 14 July 2021, where the claimant testified as CW1 by adopting her witness statement on oath, dated 12 April 2019, and tendered the following documents as exhibits: letter of appointment, exhibit GD1, confirmation letter, exhibit GD2, dismissal letter, exhibit GD3, charge sheet, exhibit GD4, certified true copy, and certified true copy of the ruling of the CMC dated 28 to 2019, exhibit GD5. Claimant was thereafter cross-examined by learned counsels to the defendant on the same date, and her case was then closed. There was no cross-examination. The defendant then opened his case on the 1st of November 2021 by calling his sole witness, Mr. Monde Alpha, who adopted his witness statement on updated 12 October 2021 as DW1. DW1 was thereafter cross-examined by learned counsel to the defendant as there was no re-examination. Defendant's case was closed. The matter was adjourned for adoption of further written addresses. Defendant further written address is dated and filed on the 8th of March 2022, wherein 3 issues for determination were submitted. Number 1, whether the court has jurisdiction to understand the malicious prosecution claim of the claimant. Number 2, whether the court can grant the contradictory claims of the claimant. Number 3, whether the claimant has by sufficient evidence proven her claims before the court to entitle her to judgment, particularly in view of her failure to deny the averment in the defendant's witness statement on oath. Counsel submitted on issue 1 that the decision of the National Industrial Court as enshrined in section 254C(1) of the Constitution of the Federal Republic of Nigeria is to the effect that the court shall have jurisdiction on labor, employment, trade unions, and related matters. That the NIC does not have jurisdiction on matters that border on malicious prosecution as held in the case of United Bank for Africa and Oladejo. That a substantial part of the pleadings of the claimant borders on malicious prosecution, which the industrial code by virtue of the constitutional provision does not have power to hear and determine. That going by the facts of this case, the claimant cannot sustain the claimant cannot sustain the tort of malicious prosecution because one of the key elements to be proved to successfully establish the tort of malicious prosecution is that the claimant should have been acquitted in the criminal case complained of, which is not the case in this matter. Counsel also submitted that in the instance case by the uncontroverted evidence of the defendant, parties have agreed to settle the criminal matter have been complained of against the claimant. The claimant under cross-examination admitted that the parties have agreed to settle the criminal matter and hence same was struck out. According to the defendant, the claim of the claimant on malicious prosecution is therefore misconceived and one that this court does not have the jurisdiction to entertain. Counsel contended on issue 2 that it is the duty of the claimant to put forward a compelling and believable case before this honorable court. That in one brief, the claimant is claiming her salaries from July 2016 till the matter is finally dispensed with, which prayer is essentially asking the court to declare that she is still an employee of the defendant. And in another brief, she is praying for 5 million general damages for wrongful dismissal. Also, therefore, argued that the claimant cannot approbate or reprobate at the same time because the two claims are without doubt contradictory of each other. The law is settled that when a claimant's case is contradictory, same will fail. Counsel on this contention cited the case of Asian and Samuel. It is a submission of counsel on issue 3 that the claimant in this case failed to put forward a convincing and compelling case of wrongful dismissal before the court. That by the uncontroverted evidence of the defendant witness after the incident of theft leading to this suit occurred on the 15th of June 2016, the claimant was questioned by the audit staff of the defendant and was allowed to go home and resume work the following day. It's also uncontroverted that one Annabelle Onwudi, who was found to be complicit in the theft, had told the police that herself and the claimant conspired to steal from the defendant. It was argued that the police is the statutory body empowered to investigate and prosecute crimes such as theft. And it was the police by its own professional decision that came to arrest the claimant on the 16th of June 2016 without prompting or inducement by the defendant. It was also argued that the defendant could not have stopped the police from arresting the claimant, as that will amount to the crime of obstruction of justice. According to the defendant, the claimant was given a fair hearing by the defendant and that the police is the ultimate body charged with the responsibility to prevent crimes and apprehend offenders, citing the case of Kobe and Usman Amfodio. That to prove a case of wrongful dismissal, reliance must be placed on the contract of employment between the parties and whether or not there has been compliance with the laid down procedure for dismissal, citing the case of Kewaram Nigeria Limited and Rosiji. Paragraph 8 of the contract of employment of the claimant, XBGD1, was also referred to. Counsel stated that the law is settled that facts not denied are deemed admitted. On this, counsel relied on the case of Haruna Labaran. It was also stated that the claimant only filed a reply to the assessment of defense without accompanying same with written deposition. That the law is clear that pleadings not supported by evidence go to no issue. Counsel submitted that the arguments of the defendant as to fair hearing given to the claimant by being questioned by the defendant's staff and asked to resume the following day is unchallenged. It is a submission of counsel that the core principles of fair hearing, which are to hear the other party and not be a judge in one's own case, were strictly adhered to by the defendant. According to the defendant, the evidence that the claimant was questioned and allowed to go home until when she was indicted by a colleague before the police is consistent with the principles of fair hearing. Contended that the claimant has failed to discharge the burden of proof placed on her to establish her claims as wrongful dismissal before this honorable court, relying on the case of Omolaji and Okaka. That the claimant has also failed to establish her unsubstantiated averment that she was detained by the staff of the defendant, having failed to state the names of the said staff who allegedly detained her, and coupled with the uncontroverted denial of same by the defendant. In conclusion, counsel urged the court to dismiss the case of the claimant. Claimant's final written address. Claimant's final written address, which is filed on 25th of March 2022, contains 4 issues for determination to it. Let me just keep them, please. Rely on the cases of Ahmed and FCSC and Olorun Tomba, Oju and Abraham, Land Council for the claimant, submitted on issue 1 that the burden of establishing wrongful termination rests on the employee by proving the 4 elements as stated in the above cited cases. Counsel also submitted that the defendant failed to comply with paragraph 7 of the terms and conditions of employment stated in the offer of employment, which provides that the claimant is entitled to 1 month's notice in writing before her employment can be terminated. Counsel further submitted that the circumstances upon which the claimant can be dismissed by the defendant in line with the paragraph 8 of the terms and conditions of employment was not established before this honorable court. That the ground of theft upon which the claimant was dismissed was not established by the defendant. That the defendant could not link the incident of theft to the claimant after investigation was conducted by them. That's in the case of Angel Shipping and Dine Company and Aja. It is a contention of counsel that the claimant was dismissed on an allegation raised by a colleague, which cannot be substantiated after investigation by the defendant and the police. That despite arraignment and prosecution of the claimant at the magistrate court, the case was struck out for want of diligent prosecution. The defendant has failed to justify the sole reason for dismissing the claimant. Counsel submitted on issue 2 that it is strict law that when an employer terminates or dismisses an employee wrongfully, the employee will be entitled to salaries and emolument he would have earned if his employment was not properly and validly terminated, such in the case of Osisanya and AfriBank Nigeria Limited. The counsel contended on issue 3 that where the employment of an employee is held to be wrongful, such employee is entitled to remedy in damages. Citing the case of Adeomi and Nigerian Eagle Flour Mills Limited. Counsel emphasized the point that in law, where there has been a wrongful termination or dismissal, a declaration by the court that the contract is subsisting will rarely be made. It has long been settled that in a master and servant relationship, a dismissal of an employee by the employer cannot be declared null and void and of no effect whatsoever. That in the case of wrongful dismissal, the only remedy is a claim in damages for that wrongful dismissal, because a servant cannot be imposed by the court on an unwilling master, even where the master's behavior is wrongful. So that's also the case of Idoni and Idoni Upu and NPC. Counsel submitted on issue 4 that by virtue of section 254C of the 1999 Constitution, this honorable court has the power to entertain, adjudicate, and decide on all matters born out of employer-employee relationship. That's in the case of Tama and Eco Electricity Institute number NIC/LA/88/2017. Judgment of which was delivered by Honorable Justice Oji. Defendant reply on points of law. Defendant's counsel filed a reply on points of law on 14th of April 2022, where he formulated 3 additional issues for determination which are contained therein. Learned counsel rehashed his points so far canvassed and argued, among others, that although this honorable court lacks the jurisdiction to entertain the claim of malicious prosecution, but assuming without considering that honorable court can entertain the claim of malicious prosecution, The claimant fell in establishing the ingredients of thought of malicious prosecution. So I think the case of Ejikeme and Onsu. Counsel finally contended, therefore, that the claimant has failed to discharge the burden of proof placed on her to establish her claims in the jurisdiction of the court. After perusing the pleadings of the parties and the evidence adduced, and considering the submission of the respective counsel for the parties, I have decided to determine two issues which I think will effectively address the whole lot of issues raised by the parties. The issues are those: number one, whether this court has the jurisdiction to entertain a claim of malicious prosecution. Number two, whether the claimant is entitled to the grant of the reliefs sought. It was the contention of the defendant on issue one that this court lacks the jurisdiction to hear a case of malicious prosecution. It is so well considered that the jurisdiction is the life wire of any suit, and any action before a court which is found to be incompetent will touch on the jurisdiction of the court, which may lead to an order striking out the action. See the case of Madukolo and Nkemdili. Similarly, jurisdiction is the power of a court to entertain and decide a case formally brought before it, which may be circumscribed by the law establishing the court or by the provision of the law requiring a thing to be done before the decision of the court can be invoked. See the case of PDP and BM and another. It is therefore imperative to consider the provision of section 254C of the National Constitution, which provides as follows. I'll skip it. Section 245C1 of the National Constitution grants the National Industrial Court wide-ranging authority to decide all disputes connected to employment and the workplace. The intention behind this provision is to eliminate restrictions on the kinds of legal claims or remedies the court can address in labor-related cases. This aligns with the well-established rule of statutory interpretation that the legislator chooses its words deliberately. No part of the law is meaningless or redundant. That the court's broad jurisdiction must be given full effect to ensure comprehensive resolution of workplace disputes. In the case of Coca-Cola and Akisanya, Ekejuba, Ojibara, and Governor of Kwara State, where the Court of Appeal stated the position thus, and I quote, "The legislature does not use words in vain. Therefore, every word, as far as possible, every word must, as far as possible, be given its natural and plain meaning." Unquote. To me, the National Industrial Court should have the jurisdiction over workplace-related legal dispute, including torts, and the jurisdiction extend to a range of employment-related issues, including, among others, defamation, assault, malicious prosecution, workplace injuries, economic loss, and duress, provided these claims originate from or are connected to the employment relationship or workplace context. This ensures the court addresses diverse legal grievances arising directly from work environment or employment interactions. It is the law that a constitutional prohibition must be given broad interpretation unless the context otherwise suggests. See the case of Skybank and EU. Certainly, no one disputes that malicious prosecution is a clear example of torts, causing frustration and distress to victims as a means of harassment to exhaust them by way of groundless and unjustified court proceedings. And when such actions occur in the place of work or during employment, it is difficult to justify why the National Industrial Court should lack civil jurisdiction over these matters. Nigeria has ratified relevant international conventions, and under Section 254C, 1F and 2 of the Constitution of the National Constitution, only the National Industrial Court has the authority to apply these conventions to workplace-related torts. These conventions serve as statutory safeguards against torts occurring in work context. If jurisdiction over workplace-related tort is transferred to other courts, which are constitutionally prohibited from applying these international labor laws, It would deprive Nigerian workers and employees of the protection afforded by this instrument. Since the other court lacks the jurisdiction to enforce them, employees will be unable to benefit from these international labor standards in tort-related cases. Thus, the NICN remains the appropriate forum for adjudicating such dispute. In the light of the above, therefore, I have no reservation assuming jurisdiction to hear this case on its merit. Issue 1 is accordingly resolved in favor of the claimant against the defendant. This takes me to the claim for malicious prosecution. It was held in Patrick and Obonna that establish a claim of malicious prosecution. The claimant has the duty to plead and lead evidence to establish that, number one, he was prosecuted in a criminal charge at the instance of the defendant. The defendant was the person who set the law in motion against him, leading to the prosecution. That the criminal prosecution terminated in his plaintiff's favor. And the prosecution was malicious, as the defendant acted without reasonable and probable cause. See the cases of Eje Kimi and Onsu, Baluguna, Amubi Kaun, Musa and Yusuf. I can see from the fact of the instance case that the defendant has a reasonable cause to report the theft incident to the police, but only for investigation, when our money was said to have been stolen. I also observed that the claimant only tendered the charge sheet and the ruling of the magistrate court terminating the proceedings. The full record of the magistrate court's proceedings is not placed before the court. To me, I think the defendant has a reasonable and probable cause to report the issue of theft to the police. And in that regard, I don't think that I do not think that a case of malicious prosecution was established against the defendant. Sorry, excuse me. For the substantive case, it is the grievance of the claimant that has summary dismissal on the account of allegation of theft raised against her by the defendant is wrongful, as she was not afforded fair hearing. Exhibit GD3 provides as follows: letter of dismissal. This letter serves as a formal means of notification to you that effective 22nd day of July 2016, you have been dismissed as pharmacy technician with MedPlus Limited. The specifics which led to this decision are gross misconduct of theft, which you perpetrated at our Sakatinibu branch. As we are well aware, gross misconducts of such magnitude are subject to dismissal in accordance with company policy. The account department has been advised to hold your security deposit. Please submit all company properties in your possession to the Human Resource Department or receipt of this letter. Yours sincerely, Human Resource Manager, on court. Meanwhile, paragraphs 5 and 8 of the Offer of Employment Exhibit 1 also state as follows. Paragraph 5, General Conduct. As an officer of the company, you will be expected to conduct yourself in accordance with the rules and regulations of the company, observing the principles and standards of the company at all times. You'll not act in any way that brings the company's name into disrepute, on court. Paragraph 8, Dismissal. Where your conduct is considered gravely disadvantageous to the company's set goals and objectives, the company can dismiss you without notice or salary in lieu of notice, on court. Now, the law is that where an employer dismissed or terminated the appointment of an employee on grounds of misconduct or any infraction, all that the employer needs to establish to justify his action is to show that the allegation was disclosed to the employee, that he was given a fair hearing. That is to say that the rules of natural justice were not breached, and the disciplinary panel followed laid down procedure, if any. See the case of Unical and Asian. It needs to be re-echoed that the most important aspect in disciplinary hearing is that it must be conducted fairly according to the rules. To be able to do this, the employee is entitled to know the nature of the charge against him in order to be able to prepare for his case. He should also be given the opportunity to state his case no matter what circumstances are. In the case of Inteo and UCTH, fair hearing is all about the opportunity of being heard. And once an employee was given ample opportunity to defend the allegation against him, then such employee cannot complain of not being given fair hearing. See the case of ZD and RSCSC, Joseph and First Bank, First Inland Bank. I note the defendant's contention that the termination of the claimant, of the employment of the claimant, was in accordance with paragraph 8 of Exhibit GD1. I also note its further contention that the claimant was questioned by the audit staff of the defendant and was allowed to go home and resume work the following day, hence giving fair hearing. It was also contended by the defendant that one Annabelle Onwodi, the claimant's co-staff, who was found to be complicit in the theft, had told the police that her safe and the claimant conspired to steal from the defendant. However, it is evident from the fact of this case as contained in the pleadings of the parties and their evidence. There is no evidence before this court to show or suggest that any query was given to the claimant about the allegation of theft or any misconduct at all. There is also no evidence of the proceedings of any disciplinary panel or the defendant's purported audit department proceedings, where the claimant and any other person or any other witness had any interface and interrogated each other about the alleged theft. In fact, the evidence of those proceedings does not exist at all. There is even no evidence from the side of the defendant of the police findings regarding the guilt or otherwise of the claimant. This is a fundamental proposition of law that an admission made by a co-accused to a police officer in charge of investigation cannot be treated as a confessional statement against the accused. However positive and direct the statement might have connected the accused with the crime. In other words, an admission can only be against its maker. Therefore, the alleged admission made by the claimant's co-staff that she conspired with the claimant to steal from the defendant is of no moment. See the case of State and Gongwon in Benue Brewery Limited and Ikechukwu Okonta. The Court of Appeal held thus, and I quote, "My lords, I'm aware that even in employment protected by statute, though not the case in the instance appeal, before an employer can dispense with the services of his employee, all that he needs to do is to afford the employee an opportunity of being heard before exercising his power of summary dismissal. Even where the allegation for which the employer is being dismissed involve accusation of crime, though there's no requirement in law that before an employer can summarily dismiss his employee from his services, the employee must be tried before a court of law, even where the accusation against the employee is for gross misconduct involving dishonesty, bordering on crime. All that is required is for the employer to satisfy the rule of natural justice and fair hearing. That a person likely to be affected directly by the disciplinary proceeding must be given adequate notice of the allegations against him to enable him make representation in his own defense. The complaint against him must not necessarily be drafted in the form of a formal charge. It is sufficient if the complaint as formulated conveys to him the nature of the accusation against him. See the case of Yusuf and Union Bank of Nigeria, Pawali JSC. See also the case of Barisa, Mr. Ramatu Umar, and British Council. I've carefully looked at exhibits GD1, GD2, and GD4, and GD5, and found that they did not support the defendant's assertion that the claimant committed any gross misconduct or infraction which led to a dismissal. I've not been able to see any evidence in support of the defendant's contention that it complied with GD1 in dismissing the claimant. I cannot agree with the purported reason of the defendant that it dismissed the claimant because of his gross misconduct of theft. I'm not persuaded that the claimant committed any theft, and there's no evidence that the claimant conspired to steal from the defendant. I agree with the submission of the Learned Council. I'm not persuaded that the claimant committed any theft, and there's no evidence that the claimant conspired to steal from the defendant. I agree with the submission of the Learned Council for the claimant that the ground of theft upon which the claimant was dismissed was not established by the defendant. The defendant could not link the incident of theft to the claimant after investigation was conducted by them. After all, the criminal charge level against the claimant at the magistrate court was struck out. On the alleged contradiction in the case of the claimant, to me, the alleged contradiction, if at all it exists, does not actually affect the case of the claimant. The fact that the claimant has simultaneously sought for two seemingly inconsistent reliefs does not affect the foundation of his case. Contradiction or inconsistency will not avail any person raising the alleged contradiction unless it is so fundamental and fatal and thus affects the life issue in the matter. See the case of Akpan states and Asanyan states. From the foregoing, therefore, I'm of the opinion that the dismissal of the claim on the ground of gross misconduct of theft without giving her the opportunity to be heard was not justified, hence wrongful. Having found that the dismissal of the claimant was wrongful, the appropriate remedy for the claimant in an ordinary contract of master and servant relationship would not be an order of specific performance of the contract of service, as to do that would amount to imposing on an unwilling master a servant he no longer desired. In case of wrongful termination, dismissal of employment, damage at the employer's appropriate remedy in law. The basis of which is that where an agreed procedure for dismissal is not followed, such failure is a breach and makes the employer liable in damages. I'm convinced that the claimant has been able to establish some of her claims to my satisfaction, and I so find. Overall, it is declared and orders as follows. A declaration that the claimant is entitled to a right to fair hearing. A declaration that the claimant was not availed with any opportunity to defend herself of the allegation of crime leveled against her, and thereby deprived her of her right to fair hearing, which led to a wrongful dismissal. A declaration that the dismissal of the claimant by issuing her a dismissal letter on the ground of an alleged criminal gross misconduct of theft without first granting her fair hearing or availing her an opportunity to defend herself before a disciplinary panel is wrongful. An order of this honorable court directing the defendant to pay the claimant the sum of 5 million naira only as damages for her wrongful dismissal, failing which it shall attract 15% interest per annum until it is fully liquidated. That's my judgment.
My Lord, we are most grateful for the well-considered judgment, and we honestly thank my Lord for this judgment. My Lord, I think I missed out when my Lord was reading out the orders, so I don't know. I heard when my Lord made mention of the declaration, that's the A, B, C, and declaration G. So I don't know if I missed out on any of it.
You know, I said the claimant has been able to prove some of her claims.
Yes, my Lord.
All those ones relating to malicious prosecution have failed and are declined.
As a couple, my Lord, what about that of G? I didn't hear anything about that. The order of this court, that of the F.
Okay.
The one to an order of this honorable court directing the defendant to pay the claimant the sum of 900.
5 million naira as general damages for wrongful dismissal.
Yes, my Lord, I got that. There is an order salary as at when the claimant was dismissed wrongfully.
No, I didn't mention that. Maybe it's in the other case. I didn't mention that. Eh?
As a court, please, because it's part of our relief too.
Which relief is that?
F, number 4. Yes, my Lord.
The
number
salary?
F. Yes, my Lord.
The salary?
Yes, my Lord.
Is the employment protected by statute?
As a court, please.
My Lord, may it please your Lordship.
Yes.
Firstly, I thank your Lordship for taking the pain to deliver this judgment despite the obvious ill health. I pray for speedy recovery for your Lordship. And I thank your Lordship. My Lord, may I just quickly mention, perhaps, I don't know, perhaps it's keep the court's attention. My Lord, our argument as to the defendant maintain an employment while she's claiming all these monies, which was in our final address, and we also canvassed orally. My Lord, I didn't hear your Lordship mention anything about it all to the judgment, sir. It's in our final address. It's also part of our oral adjudication at the last proceedings. Perhaps it's keep my Lord's attention. I don't know. I just thought I should bring that to the court's attention. But regardless, sir, I thank your Lordship.
My Lord, we are going to be asking for cost, my Lord, because cost follows events. The claimant has expended some money to prosecute this case, my Lord, and we'll be asking for cost of 1 million naira. My Lord.
My Lord, may it please your Lordship, sir. May it please your Lordship, sir. May I proceed, sir?
I said I'm not awarding any cost, please.
I thank you.
As a cop, please.
Yes, sir. My Lord, I raised an issue earlier with due respect, sir, that our argument as regards our submission and our written address, as regards
I'm official, Mr. Yes.
As a cop, please.
I concede to your Lordship. I'm just saying perhaps it was a slip. The law
when you get the full judgment, hello, can you hear me?
Follow me, sir.
I said when you get the full judgment, you go to the areas that you want to.
As a couple, I thank your Lordship immensely.
We'll be sending it. Yes, maybe next week. We'll be sending it next week.
As God pleases.
Once
We're
it's
grateful,
created,
sir.
I will ask my registrar to send it to Lagos.
As God pleases. I thank you, Lordship.
Yeah, we are most good.
Thank you.
My Lord, for the sake of the nation and the body of legal practitioners, please speak medical attention to this, sir.
God willing, I will do.
Thank you, my Lord.
Thank you so much. So in the absence of any other thing, I wish you good afternoon.
Thank you, my Lord.
And happy weekend in advance.
Thank you, my Lord.
Thank you.
And your Lordship too.
Thank you too. Thank you.
Yes,
and bye. Thank you.
Bye-bye, sir.
Okay, bye-bye.